many questions to 1, 2, 3, 4. 4 questions pa to. Pwedeng after nito, i-end natin to, tas another recording for live para another episode yung contracts.
Okay, sige. Good morning!
Good morning. We're live na pala. Okay, so we left yesterday accidentally, technical problem, with the extinguishment of obligation. So this is a continuation of extinguishment of obligations. Then later on, we'll have contracts. So, okay, friends, good morning. Can you please read the first question?
Ayan. So, Sarah had a deposit in a savings account with Filipino Universal Bank in the amount of 5 million pesos. To buy a new car, she obtained a loan from the same bank in the amount of 1.2 million, payable in 12 monthly installments. So, Sarah issued in favor of the bank post-dated checks, each in the amount of 100,000 to cover the 12 monthly installment payments. On the third, fourth, and fifth months, the corresponding checks bounced. The bank then declared the whole obligation due and proceeded to deduct the amount of 1 million pesos from Sarah's deposit after notice to her that this is a form of compensation allowed by law. So is the bank correct?
Okay, so Sarah daw nag-deposit in a savings account with FUB, Filipino Universal Bank, ng 5 million to buy a new car. Mahal naman ng car na to. Ano bang car yung nag-worth 5M?
Velus.
Ha? What?
1.2 lang.
Anong car?
Velus. Yung kila ano. Yung ganun. Masa 1.2 ata yun.
Toyota lang naman yun.
Diba?
Mura lang yun.
Eh. Ewan ko.
Kaya nga, anong car mga 5M na. Mura na to. Parang in the middle. Ford, ganyan. So to buy a new car, she obtain a loan from the same bank in the amount of 1.2. Okay. So yung car is 1.2 lang naman.
Yung 5
okay.
deposit.
Sige. Payable in 12 monthly installments. So 100,000 to monthly. Sarah issued in favor of the bank post-dated checks, each in the amount of 100,000 to cover for 12 monthly installment payments. So on the third, fourth, and fifth month, the corresponding checks bounce. Okay, so the bank then declared the whole obligation due and proceeded to deduct the amount of 1 million pesos from Sarah's deposit after notice to her. This is a form of compensation allowed by law. Is the bank correct? Okay, so just because nag-bounce yung check ko, may karapatan ka na i-deduct yun from my deposit? Yes or no? So here, no, the bank is not correct. While the bank is correct about the applicability of compensation, it was not correct as to the amount compensated. A bank deposit is a contract of loan where the depositor is the creditor. Sabi niya, ikaw yung mayaman dyan, ikaw yung nag-utang di ba? And the bank, the debtor. Since Sarah is also the debtor of the bank with respect to the loan, both are mutually principal debtors, creditors of each other. Both obligations are due, demandable, and liquidated, but only up to the extent of 300,000, covering the unpaid third, fourth, and fifth monthly installments. The entire 1 million was not yet due because the loan has no acceleration clause in case of default. And since there is no retention or controversy commenced by third persons and communicated in due time to the debtor, then all the requisites of legal compensation are present, but only up to the amount of 300,000. The bank, therefore, may deduct 300,000 from Sarah's bank deposit by way of compensation. Kailangan ko itong i-memorize. Legal compensation. What are the requisites of legal compensation? Kasi hindi ko talaga ito nakuha nung sa banking exam ko But dito pa ulit-ulit siya tinatanong, no?
Oo.
Kaya can you research legal compensations requisites tas forward mo sa ino ko?
1279 siya. In order that compensation may be proper, it is
Hmm.
necessary, number one, that each of the obligations be bound principally and that he be at the same time a principal creditor of the other. Number two, that both debts consist in a sum of money, or if the things due are consumable, they be of the same kind and also of the same quality if the later has been stated. Number three, that the two debts are due. And four, that they be liquidated and demandable. And five, that over neither of them there be any retention or controversy commenced by third persons and communicated in due time to the debtor. Sa inyong mga requirements.
Paulit-ulit ang itatanong sa ano. Either civil law or
Oo,
commercial law. Yan, mga ano kasi yan eh.
this has to be
Overlapping.
memorized.
Pwede bang ito yung next na i-memorize? Yung dun sa donation na article, dapat the requisites din yung pinapamemorize mo sa akin dun. Not just the definitions. Kasi yun yung mga parang ano, elements.
Sige.
Kasi kapag nakita ko ni Dean, verbatim na memorize mo. Do you think?
Understand the verbatim. You also understand that.
Ha?
You memorize it, but you also understand.
Yeah. I'm more of understanding first before verbatimly memorizing it. Kasi kapag naiintindihan mo siya, mas madali mo siyang ma-memorize. Kaysa yung verbatim mo memorize, tapos di mo siya magets, it bounces.
Ah.
Hindi ko siya parang walang long term dun.
Walang long-term retention.
So yan, makulay na.
Good then if you teach it to someone else. Kasi doon, intindihan mo doon.
So, nasa na yung highlight ko? Nawala.
So may 5 requisites.
Okay. So, dito, is the bank correct? So, nung sinagot niya na oo daw, ay hindi daw correct. Kasi, ang ginawa ng bank, the bank declared the whole obligation due, no 1 million. What if, may binagbudgetan pa rin nun si, diba, si Sarah. From Sarah's deposit after the notice third, it is formal compensation allowed by law. So, tama naman sana yung application of compensation. Pero doon lang sa amount na 300,000. So, in order for it na maging tama nga ba, ano yung requisites na kailangan niyang ma-fulfill? So, una, bawat isa sa kanila be bound principally that he be at the same time a principal creditor of the other. So, dun nga si Sarah, may utang siyang car. And then at the same time, si Sarah ay nagpapautang sa bangko kasi nga it's a contract of loan hindi siya contract of deposit. Kumbaga, creditor si Sarah as a depositor.
Depositor is considered a creditor.
Contract of loan. Ikaw yung nagpapautang doon. Kasi yun nga, sa banking laws, ganyan-ganyan. A bank will not be a bank unless nagpapautang. Nagpapautang ka. So, ang ginagawa ng bank, they accept deposits. Tapos nagpapaloan sila sa iba. Tapos isi-charge ka na, 5% monthly. Tapos bibigyan ka ng 0.025 interest return. O, diba? Luging-lugi ka. Kaya, maghanap ka na yung ibang investment vehicle. Ayan. So, dito, they're both bound nga daw, principally. So, tas pangalawa, both debts consist in a sum of money. So, parehong pera. Hindi ito pwede maging dasyon impago, no? Kasi both sum of money daw di ba? Oh, ito, pwede ba naman daw? Or if the things due or consumable. So, what if consumable? How about rice?
Palitan mo ng rice.
They be of the same kind and also of the same quality. Rice. And if yung pinautang mo sa akin, don't expect me na bigyan kita ng denorado. Ayun siya. Of the same quality. That the two debts be due. Okay, due naman siya. That they be liquidated and demandable. Dito mali lang yung pagkaka-liquidate, no? Kasi yung ginawa 1 million agad. Pero, yun. So, yung 300,000, okay. Okay yun. That over neither of them there be any retention or controversy. Anong controversy to? Commenced by third persons and communicated in due time to the debtor. Wala namang may third persons na. Okay.
So dun sa nagkamali ba sa ano? Sa 4?
Ay, hindi. All the requisites are,
All the requisites are present.
are complied with. So that's why the legal compensation is applicable.
Pero in so far only as 300
Kumbaga may limit lang yun. 300,000 lang.
dun lang sa demandable.
Kasi hindi pa demandable yung 6 months onwards. Diba for 1 year yun?
Okay.
Okay.
Alright.
Send mo to sa akin mamaya. May civil code naman ako. Nagpa-send pa. Pabebe lang. Game na. Next.
Question. In 1978, Bobby borrowed 1 million from Chito payable in 2 years. The loan, which was evidenced by a promissory note, was secured by a mortgage on real property. No action was filed by Chito to collect the loan or to foreclose the mortgage. But in 1991, tagal naman, Bobby, without receiving any amount from Chito, executed another promissory note, except for the date thereof, which was the date of its execution. So, may tanong ba to? Can Chito demand payment on the 1991 promissory note in 1994?
Okay. Pwede daw bang i-demand yung payment on the 1991 promissory note in 1994? Kung ginawa mo siya ng 1991, i-demand mo ng 1994. Tingnan natin. So, analyze muna natin. Balikan muna natin siya. So, si Bobby, nanghiram ng 1M kay Chito. Dapat 2 years. 2 years lang. 1978. So, dapat 78, 79, 90. 70. Oh my God. Pagbibilang ko. 1978 to 1980. Parang si Miel, naririnig ko. 6, 7, 8, 9. Yan. Tapos iba-iba na yung mga magkakasunod-sunod.
6, 7, 10. Ganyan.
The loan, which was evidenced by a promissory note, was secured by a mortgage on real property. Okay, may promissory note ka sa akin, pero gusto ko may mortgage ka. Tapos, no action was filed by Chito to collect the loan or to foreclose the mortgage. But in 1991, Bobby, without receiving any amount from Chito, executed another promissory note, except for the date thereof, which was the date of its execution. Hindi ko masyado gets. But in 1991, Bobby, without receiving any amount, hindi naka-receive si Bobby?
Oo.
Siya ngayon ang hiram, diba? Kay Chito. Without receiving any amount from Chito, nag-execute na ulit siya ng promissory note. Kumbaga, ba't ka gagawa ng promissory note? Tapos wala ka namang nare-receive. Except for the date thereof. Ano yung date na yun? Which was the date of its execution, ha?
1991. Yung date.
So, does it mean binabago niya lang yung date? Wala naman siyang na-receive eh. Medyo hindi siya
Hindi malinaw kung ano yung purpose niya.
But in 1991, Bobby, without receiving any amount, wala. 1991, anong nangyari sa 1991? Si Bobby daw, wala namang na-receive any amount from Chito. Pero nag-execute ulit siya ng promissory note, except for the date thereof, which was the date of its execution. Ano yung banda dun? Nagets mo?
Hindi rin.
Anyways, sige, punta tayo sa question. So, can Chito demand payment on the 1991 promissory note in 1994? So, parang ang gusto lang ba dito ni Bobby, babaguhin natin yung promissory note mo para payable in 2 years. 1991 natin i-date, tapos 1994 mo na babayaran. So, here, yes.
Yung payment, ganun? Ano ba? Hindi ko rin alam.
Oo, medyo complicated yung problem. No? Pag magulo yung problem, minsan hindi mo rin alam paano sasagutin. But it says here, yes, Chito can demand payment on the 1991 promissory note. In 1994, although the 1978 promissory note for 1 million payable for 2 years, later, or in 1980 became a natural obligation after the lapse of 10 years, such natural obligation can be a valid consideration of an abated promissory note dated in 1991 and payable 2 years later or in 1993. All the elements of an implied real novation are present. Okay, so parang ano to, nagkaroon ng novation. So requisites na to ng novation. An old valid obligation, a new valid obligation, capacity of the parties, the animus novandi or intention to novate, and E, the old and new obligation should be incompatible with each other on all material points. So yung Article 1912. 1292.
1292.
The two promissory notes cannot stand together, hence the period of prescription of 10 years has not yet lapsed. So parang ano to, pag nagkautang ka in 10 years, tapos di mo siningil, may prescription din pala siya.
Oo.
Pautang ng 1 million, ganun. Ayos ka. Nag-lapse ng 10 years. Pero it became daw a natural obligation.
What's a
Meron,
obligation?
meron pa kasi different kinds of obligation. Different kinds of obligation, research pa.
Sige. A natural obligation is one which cannot be enforced by action, but which is binding on the party who makes it in conscience and according to natural justice. A civil obligation is a legal tie which gives the party with whom it is contracted the right of enforcing its performance by law.
Okay. So nung una, yung within 2 years, civil siya kasi enforceable nga. So
Oo.
kapag halimbawa 10 years na siya, naging natural obligations, parang konsensya mo na lang.
Siya mo na lang. Utang ka, paano ka ba? Bayaran mo na.
Pero yun nga, ano na siya, ay naalala ko may utang pala ako sa'yo, ganyan-ganyan. On the 2 years, on the third year, parang it became a natural obligation na siya kasi yung civil obligation parang within 2 years lang, no? Parang demandable. Kaso, parang pag friends kayo, nakalimutan na nga yun, natural obligation. Pero yun nga, if after 10 years, ganun pa din, pwedeng mag-prescribe. Friendship naman kayo, ganyan. Diba?
So 10 years lang pala pag-utang, tapos wala na. Hindi mo na pwedeng ano. Hindi, it becomes natural obligation after 10 years.
Konsensya mo na lang, magbabayad ka, tanggapin mo. Pero iba rin yung siguro yung sa mga kaso, di ba, na parang paid until, ay, parang may interest hanggang sa di mo bayaran, the interest will accrue.
So what will happen pag ganun?
Papile up siya. Pag di na naman nagkasundo, the court will fix it. Masyado namang mataas yung interest mo.
Payment arrangement. Pag payment arrangement, novation na yun.
Saan?
Novation na ba yun?
Basta sinasabi lang naman sa novation kasi, the old contract is existing, and then the old contract is being renewed, and then the old and the new are incompatible. And then there's really an intention to novate. Ayun.
Parang ganun eh. Pag nag-payment arrangement ka, di ba? Kasi it's no longer the original contract. Tapos,
Kung babaguhin mo lang yung payment arrangement mo.
di ba originally, parang okay, pay me 10,000, ganyan. Tapos interest is 20%, ganyan. Tapos hindi nakabayad, sige. Instead na magkorte tayo, payment arrangement na lang tayo. So yung 10,000 mo, instead na demandable siya agad-agad, it will be over 6 months, and then instead na 20%, so sige, 10% na lang, ganyan. So, parang, di ba, the obligation is there, old obligation is still there, may new obligation ka, since hindi mo kayang bayaran ng 20%, so sige, mag 10% tayo sa capacity of the parties, and then may intention din to novate kasi bagong kontrata, payment arrangement. Pero yung E, the old and the new obligation should be incompatible with each other on all material points.
Incompatible sila. Kumbaga, hindi sila pareho eh.
What does that mean? Parang it's either one or the other lang, no? Okay. All right. So, parang feeling ko nga it meets all the requirements.
Okay.
Arrangement.
May pangalawa siyang question eh.
So, can Chito foreclose? Si Chito yung inutangan. Can Chito foreclose the real estate mortgage if Bobby fails to make good his obligation under the 1991 promissory note?
Pwede daw ba i-foreclose ni Chito yung real estate mortgage if Bobby fails to make good his obligation under the 1991 promissory note? Sana sagot. Foreclose na lang natin tong property mo. Hindi ka makapagbayad eh. No. The mortgage being an accessory contract prescribed with the loan, the novation of the loan, however, did not expressly include the mortgage, hence the mortgage is extinguished under Article 1296 of the New Civil Code. The contract has been extinguished by the novation or extinction of the principal obligation insofar as third parties are concerned. So dito, anong pagkakagets mo dito?
Parang ano siya, part siya nung original na kontrata.
Alin?
Tapos yung, 'di ba, part siya nung 1978 loan. Accessory siya doon. Tapos dun sa bagong promissory note na 1991, wala daw sinabi na kasama yung mortgage. Parang na-extinguish siya under Article 1296. Sabi sa 1296, when the principal obligation is extinguished in consequence of innovation, accessory obligations may subsist only insofar as they may benefit third persons who did not give their consent. So, ano to, kung sangla siguro to sa ibang tao, no? May third party na involved, then it will subsist. Pero kung wala naman, there's no other party involved, then may extinguish yung
Kanino ba minortgage?
kay ano, kay Bobby. Kay sino to nga to? Si Chito.
So para siyang ginawang collateral sa'yo.
Kinolateral siya.
Kasi usually, 'di ba? Pag umutang ka sa bank, bibigay mo din yung bahay mo doon, ganyan, 'di ba? Pag may mortgage. So kapag di ka magbayad, kukunin nila yung bank, yung bahay, 'di ba? Ganun. So dito si Chito, sige, pautangan kita 1 million. So parang si Chito yung bank, no? Just trying to visualize. So si Chito, nagpautang na 1 million. Okay, pero gusto ko may collateral yan. We call it collateral, no? In a sense, sa Bicol, ganun. Hindi kita pautangin kung walang parang backup plan, diba? Parang backup plan yun eh. So since nga nung una, kasama yon yung pag-mortgage, kaso nung pangalawa na hindi naman nila.
Hindi naman na isama daw.
So dito, walang involved na third party kasi kay Chito ka rin nag-mortgage, no?
Pero what if halimbawa sino isa? Si Bobby, halimbawa, dinonate niya yung portion ng lupa sa ibang tao.
Ba't ka magdodonate?
Party na involved, di ba? So, kailangan mag-subsist yung ano. Tama ba?
Hindi, iba na yan.
Iba na yun.
Later na lang muna yung donation. Basta wala namang involved na
so dito, wala namang third party or third person.
Walang third party na affected.
Okay.
Basahin ko lang ulit. So the mortgage being accessory contract prescribed with the loan. Nag-prescribe din daw siya with the loan. Okay, the novation of the loan, however, did not expressly include the mortgage, hence the mortgage extinguished under Article 1296 of the Civil Code. The contract has been extinguished by the novation or extinction of the principal obligation insofar as third parties are concerned. Okay, next question.
Next one. Baldomero leased his house with a telephone to Jose. The lease contract provided that Jose shall pay for all electricity, water, and telephone services in the leased premises during the period of the lease. 6 months later, Jose surreptitiously vacated the premises. Bakit kaya? He left behind unpaid telephone bills for overseas telephone calls amounting to over 20,000. Baldomero refused to pay said bills on the ground that Jose had already substituted him as the customer of the telephone company. The latter maintained that Baldomero remained as his customer as far as their service contract was concerned, notwithstanding the lease contract between Baldomero and Jose. Who is correct, Baldomero or the telephone company?
Okay, so dito daw si Baldomero pinapaupahan yung bahay niya na may telephone kay Jose.
Oh,
And then yung contract nagsasabi na, "Oy, Jose, bayaran mo lahat ng electricity, tubig, telepono dun sa nirerentahan mo ngayon." Si Jose, ano 'tong surreptitiously nga, anong ibig sabihin nito? Parang patago?
tago, paano?
Mali siya. Tapos
Stealthily.
stealthily,
Oh,
and then mali siya, walang bayad yung telepono. For overseas calls amounting to 20,000, siguro may ka-LDR 'to,
oh,
'no?
wala
20 ha?
pang Skype.
Oo. Mahal, 20,000. So, Baldomero refused to pay the said bills. Ayokong bayaran 'yan. Refused to pay the said bills on the ground that Jose had already substituted him as a customer of the telephone company. So, the latter maintained that Baldomero remained as his customer as far as their service contract was concerned. Okay, so halimbawa siguro Smart 2 or PLDT, no?
Hmm.
Okay, ikaw yung naka-register dito, owner. So, ikaw magbayad, Baldomero. Ah, so who is correct? Si Baldomero ba? Or the telephone company? Ikaw, Baldomero, magbayad ka. Kasi ikaw yung nasa kontrata namin. Sabi naman niya, Baldomero. Hindi ako, may pinarentahan kasi ako dito ng ano eh. May nagrenta dito, siya yung nag-spend niyan eh. So, sino daw ba talaga dapat? The telephone company is
Feeling
correct
yeah.
because as far as it is concerned, the only person it contracted with was Baldomero. The telephone company has no contact with Jose. Baldomero cannot substitute Jose in his stead without the consent of the telephone company. That's Article 1293. Baldomero is therefore liable under the contract. Totoo naman, 1293. Hey, this one is very common sense, diba? Ikaw
Oh,
naka-pirma sa with the telephone company eh.
1293, novation, which consists in substituting a new debtor in the place of the original one, may be made even without the knowledge or the will of the latter, but not without the consent of the creditor. So payment by the new debtor gives him the rights mentioned in Articles 1236 and 1237.
Ano yung 1236 and 1237?
1236.
The creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of the obligation unless there is a stipulation to the contrary. Okay, so dapat may stipulation. Whoever pays for another may demand from the debtor what he has paid except that if he paid without the knowledge or against the will of the debtor, he can recover only insofar as the payment has been beneficial to the debtor. 1237, whoever pays on behalf of the debtor without the knowledge or against the will of the latter cannot compel the creditor to subrogate him in his rights, such as those arising from a mortgage, guarantee, or penalty. So, sinasabi lang dito, dun sa 1293,
Hmm.
the vision which consists in substituting a new debtor. Kumbaga, gusto kasi palabasin dito ni Valderemo. Hindi na ako yung debtor eh. Ang debtor na is si Jose.
Okay.
Kasi nga, siya naman talaga yung gumamit nung mga telephone calls na yun. So dito, pwede. The vision which consists in substituting a new debtor in the place of the original one may be made without the consent or knowledge, without the knowledge or against the will of the latter. So sino yung latter dito?
Debtor. Whoever pays for another may demand from the debtor what he has
Wait,
paid.
we are in 1293.
Ha?
We are in 1293.
1293?
Yes.
36 ako.
So novation which consists, again, novation which consists in substituting a new debtor in the place of the original one may be made even without the knowledge or against the will of the latter, but without the consent of the creditor. Pwede mo siyang gawin, okay, may innovation na nangyari. Maybe made without the knowledge or against the will of the latter. Sino si latter dito? Yung debtor?
Debtor.
New debtor? Okay, so payment, but not without the consent of the creditor. So, sino yung creditor dito?
Si telepono.
Okay, di nyo pinaalam sa akin. But, so, a very big but. Kailangan, kung may mangyayaring ganun, paalam nyo sa akin, may consent. So, siguro may pipirmahan na forms, diba? At least, alam ko, acknowledge ko, diba? Payment by the new debtor gives him the rights mentioned in Articles 1236 and 1237. So, here, kailangan may consent niya sa 1293. Yun lang yun, diba?
Ah,
Kasi nga, kung ano na, naging effective naman na yun, then we go back dun sa 1236 and 1237, which is under nga, yung extinguishment of obligations. Or yung payment pala, payment or performance. Yun. Dun na siya mag-govern. Okay, so...
debtor in place of the original one.
Hmm?
The original one. The original one. Hindi, binabasa ko lang ulit yung 1293. The latter is the the original debtor. So novation, which consists in substituting a new debtor in the place of the original one. So the latter one is the original one. Okay.
O yung kanina.
Mm.
Oh, kasi the new debtor will be the former. Alam mo yung use ng former and latter, di ba?
Former. Yun
Minsan
yung former.
kailangan ko siyang i-ano eh. Kailangan ko siyang i-distinguish at i-label. Sino si former, sino si latter. This is discouraged already. The use of such.
Language niya, di ba?
Just be more, yeah, just be more specific. So, sino yung latter na yan? Sino yung former na yan? Mention mo na lang. Kaya ko I seldom use this or never use this at all. Kasi nakakagigil. Nakakagigil. Pwede mo naman sabihin, pa-latter-latter ka pa dyan.
To have a lot of patience, understanding the line. Kasi, di ba? 90% of these are old laws.
True.
Language
Okay.
napaka-archaic. Question. The sugarcane planters of Batangas entered into a long-term milling contract with the Central Azucarera de Don Pedro Incorporated. 10 years later, the Central assigned its rights to the said milling contract to a Taiwanese group which would take over the operations of the sugar mill. The planters filed an action to annul the said assignment on the ground that the Taiwanese group was not registered with the Board of Investment. So will the action prosper or not?
Okay, so may sugarcane sa Batangas. Sugarcane planters, no? They entered into a long-term milling contract with Central Azucarera de Don Pedro Inc. So yun, 10 years later, si Central daw assigned its rights to the said milling contract to a Taiwanese group. Okay, which would take over the operations of the sugar mill. So the planters filed an action to annul the said assignment on the ground that the Taiwanese group was not registered with the Board of Investment. So will the action prosper or not? Feeling ko yes. Pero sabi dito, the action will prosper not on the ground invoked, but on the ground that the farmers have not given their consent to the assignment. Oo nga naman. Yung mga farmers yun eh. So the milling contract imposes reciprocal obligations on the parties. The Sugar Central has the obligation to mill the sugar cane of the farmers, while the latter have the obligation to deliver their sugar cane to the Sugar Central. As to the obligation to mill the sugar cane, the Sugar Central is a debtor of the farmers. In assigning its rights under the contract, the Sugar Central will also transfer to the Taiwanese its obligations to mill the sugarcane of the farmers. So this will amount to an evasion of the contract by substituting the debtor with the third party. Under Article 1293 of the Civil Code, such substitution cannot take effect without the consent of the debt of the creditor. The farmers who are creditors, as far as the obligation to mill their sugarcane is concerned, may announce such assignment for not having given their consent thereto. Haba na explanation.
1293.
Ayun, yung kabasa ko lang kanina. Hindi pwedeng mag-take effect yung novation without the consent, 'di ba? So dahil walang consent nga ng creditor, hindi pwede, 'di ba? Pero bakit naging ano to? Bakit naging creditor si farmers?
Kasi sila yung nag-render ng service.
Oh, kasi they have the obligation to mill the sugarcane of the farmers. Pero they're both, di ba? Kasi the latter have the obligation then to deliver their sugarcane to the central.
Mutual
Kumbaga, reciprocal siya.
pala sila.
Okay, pero yung creditor na kinukonsider dito are the farmers. Why?
So, kasi may third party na. So, di ba, parang na-retain ni farmer yung pagiging creditor niya. May new debtor, may old debtor. So, hindi pwedeng debtor to debtor lang yung usapan. Dapat kasama din yung creditor. May consent.
Okay, basta yung debtor dito. Si Taiwan, ay,
Yung
third
new.
party na si Taiwanese eh. Si company na to. Ano ang pangalan niya? Central Azucarera de Don Pedro Inc. Siya na yung debtor dito.
Novation.
Okay. Debtor, tapos creditor. Okay, walang consent ng mga farmers eh. Pero mali yung ground nga daw na ini-invoke nila, di ba?
Kailangan i-modify nila.
On the ground that the Taiwanese group was not registered with the Board of Investment. Saan ba yung Board of Investment? Baka dapat i-file sa sa SEC. Hindi ba sila nagpa-file sa SEC? Bakit sa Board of Investment? Who is BOI? Who is BOI? Board of Investment dito. Pero ba tayo nito? Baka sa SEC, ibig sabihin din nila to. Anyways, next. Okay, basta hindi pwede.
Tingnan nga natin. Gusto ko lang tingnan.
Alin?
Attach siya sa DTI, yung Board of Investment.
Okay, so if it's proprietorship, DTI ka. Pero kung corporation ka, SEC ka.
BOI.
Kung Taiwanese to, it would involve Filipinos. Foreigners. Okay, next. Basta yun, kailangan ng consent ni creditor. Walang consent, hindi pwede. Diba?
Next one. Samantha sold all her business interests in a sole proprietorship to Serio for the amount of 1 million. Under the sale agreement, Samantha was supposed to pay for all prior unpaid utility bills incurred by the sole proprietorship. A month later, after the contract to sell was executed, Samantha still has not paid the 50,000 electricity bills incurred prior to the sale. Since Serio could not operate the business without electricity and the utility company refused to restore electricity services unless the unpaid bills were settled in full, Serio had to pay the unpaid electricity bills. When the date for payment arrived, Serio only tendered 950,000, representing the full purchase price less the amount he paid for the unpaid utility bills. Samantha refused to accept the tender on the ground that she was the one supposed to pay the bills and Serio did not have authorization to pay on her behalf. Binayaran mo. May tanong ba dito? What is the effect of payment made by Serio without the knowledge and consent of Samantha?
Okay. Let's analyze. Samantha daw, binenta all her business interests in a sole proprietorship to Serio. Okay. For how much? 1 million. So under the sale agreement, Samantha was supposed to pay for all unpaid utility bills. No, daming utang siguro nito sa Meralco. Incurred by the sole proprietorship. So a month after the contract to sell was executed, Samantha still had not paid the 50,000 grabe naman. Laki naman ito. 50,000 electricity bills incurred prior to the sale. So since Serio could not operate the business without electricity, and the utility company refused to restore electricity services unless unpaid bills were settled. Oo nga naman. Hirap magtrabaho walang kuryente. So, Serio had to pay the unpaid electricity bills. So, when the date for payment arrived, Serio only tendered 950,000, representing the full purchase price. Kasi dapat originally 1M. So, less the amount he paid for the unpaid utility bill. So, Samantha refused to accept the tender on the ground that she was the one supposed to pay the bill, since Serio did not have authorization to pay on her behalf. Refused to accept the tender on the ground that she was the one supposed to pay the bill, since Serio did not have the authorization to pay on her behalf. Ano ba, Samantha? Binayaran na nga eh. Ba't may pa-refuse ka pa to accept the tender? What is the effect of payment made by Serio without the knowledge and consent of Samantha? So the payment by Serio resulted in the extinguishment of the obligation of Samantha to the utility company, and Serio was legally subrogated to the utility company's credit. Serio thus became Samantha's new creditor. Nagpautang na tuloy si Serio. Under Article 1303 or 1302 paragraph 3 Civil Code, it is presumed that there is legal subrogation when, even without the knowledge of the debtor, a person interested in the fulfillment of the obligation pays without prejudice to the effects of confusion as to the latter share. A person interested in the fulfillment is one who will benefit from the extinguishment of the obligation. So dito parang gusto nang bayaran niya, no? Para magamit niya na, di ba? Yung business nga yun doon sa sole proprietorship. So since di pa bayad, kailangan niya lang bayaran. So here, serious and interested person, since he was the business successor in interest of the Samantha, of Samantha's business maybe, and he cannot conduct his business without paying the debtor. Babe, this should be the debts of Samantha, di ba? Bakit mali-mali yung mga words nila? Sisters, sorry na. Since there is legal subrogation, Sirius tapped into the shoes of the utility company as the new creditor of the 50,000 credit. Thus, there can be a valid legal compensation of the two credits between him and Samantha, who are principally debtors and creditors of each other up to the concurrent amount of 50,000. Okay, so we're still talking about legal compensation here, no? Diba?
Oo.
Okay, binayaran ko yung 50,000 mo. So ikaw, may utang ka rin sa akin 50,000. So legal compensation yun.
Pero yung kaninang binasa natin, 1237, sabi niya, whoever pays on behalf of the debtor without the knowledge or against the will of the latter cannot compel the creditor to subrogate him in his rights as those arising from a mortgage guarantee or penalty.
Nabanggit ba yun dito?
Hindi. Yung kanina lang na binasa natin na isa. 1236, 1237.
Ano ba pagkakaintindi mo dyan sa 1237?
Parang halimbawa, ikaw may utang ka, binayaran ko yung utang mo without you knowing it. Hindi ko pwedeng sabihin, bayaran mo yung utang mo. Ako na yung, saan ka na magbayad kasi binayaran ko na.
Pero meron din kasi dito na sinasabi na sa 1302 paragraph 3, it is presumed that there is legal subrogation when, even without the knowledge of the debtor, a person interested in the fulfillment of the obligation pays without prejudice to the effects of confusion as to the latter share. Medyo kulang siya. 1302 paragraph 3.
When, even without the knowledge of a debtor, a person interested in the fulfillment of the obligation pays without prejudice to the effects of confusion as to the latter share. Kasi parang...
Ang tanong, what is legal subrogation? Parang substitution to, di ba?
Oo. Meron kasing benefit kay ano? kay Sergio, kung babayaran,
Interested kasi siya, oo, interested siya kaya bayaran. Uy, bayaran ko na 'to, kasi hindi ako makakapag-conduct
sa business.
ng business kapag wala, eh. So, can you find meaning of legal subrogation? Usually kasi hindi dinidefine dito yung legal subrogation, eh. Pabasa po ng legal subrogation.
Okay, wait lang. So subrogation is a substitution of one person by another with reference to a lawful claim or right, so that he who substitutes another succeeds to the rights of the other in relation to a debt or claim, including its remedies or securities. So yun nga.
Okay, so may legal subrogation.
2207.
Hmm?
2207. Okay. Anyway. Ayun. Yung ano. Ay, wait. Merong legal tsaka conventional subrogation.
Yung legal subrogation tayo.
Without agreement but by operation of law. Yung legal
Yung legal.
Ah.
Okay, hindi kayo nag-agree so by operations of law. Ano yung conventional?
Wait lang. Open ko lang tong isa. Convention is which takes place by agreement ng parties.
Hmm?
Agreement ng parties.
Okay. You have to agree. Yung isa walang agreement pero
So,
by
walang
operations of
agreement,
law.
parang by operation of law lang.
Which happens in 1302 nga. And then pasok tong case nila sa Malta and Serio dun sa paragraph 3, when even without the knowledge of the debtor, a person interested in the fulfillment of the obligation pays without prejudice to the effects of confusion as to the latter share. Okay, ito dito. Meron palang parang definition yung subrogation. 1303, subrogation transferred to the person subrogated the credit with all the rights thereto pertaining either against the debtors or against third persons, but they guarantors, be they guarantors or possessors of mortgages, subject to stipulation in a conventional subrogation. Basahin ko na lang pababa. A creditor to whom partial payment has been made may exercise his right for the remainder, and he shall be referred to the person who has been subrogated in his place in virtue of the partial payment of the same credit. Yay! Tapos na natin yung obligations. Meron pa ba?
Ano ba yan?
Last na, no? Meron pang isang pangalawang question. Okay.
Samantha guilty of mora accipendi. Mora.
Okay. So, can you muna? Research what is mora accipendi bago natin sagutin. What is mora accipendi?
Mora accipendi, the delay on the part of the creditor without justifiable reason to accept the performance of the obligation.
So, delay siya.
Dinilay niya yung bayad. Napilitan tuloy si Sergio.
Napilitan
Bayad. Paluwal. Mag-advance. Anong tawag doon?
Nag-pay siya in advance.
Hindi naman in advance, pero parang ganun na nga.
He just paid the credit or the debts of Samantha in advance. In terms ng utility niya nga. Payment, bills, utility bills. Okay, so here, yes, Samantha is guilty of mora accipendi. The requisites for mora accipendi are 1, offer of performance by the debtor. 2, offer must be to comply with prestation as it should be performed. And 3, the creditor refuses to accept the performance without just cause. Here, Serio validly made an offer to comply with the prestation of payment, albeit for 950,000 only. Serious offers justified based on the concept of partial legal compensation up to the amount of 50,000. Since Seri and Samantha are in their own right principal debtors and creditors of each other, Samantha's refusal was without just cause, as she cannot be permitted to benefit or use as a defense her own failure to fulfill her part of the obligation to pay the electricity bills. Ano sabi?
Oh, justified nga si Sergio.
Na.
Parang i-ano na, ibawas na yung 50,000 kasi binayad ko na to eh. So sige. Babawas ko na lang sa due ko. Parang naging compensation na siya. Diba yung principal debtors, due and
Hmm.
demandable. Ganon. So, yun. Under that provision ng compensation, pwede nang ibawas ni Sergio.
Okay. Ito yung requisites again ng more accipiendi. Basta delay siya, no? So, one, offer performance by the debtor. So, sino yung debtor dito?
Si Samantha.
May offer ba siya? Offer must be comply with prestation as it should be performed. 3, the creditor refuses to accept the performance without just cause.
So, parang offer of performance by the debtor. Magbabayad ng 50,000. Offer be to comply with prestation as it should be performed. Ano yung prestation?
Anong sabi?
A rent, tax, or due paid in kind or in services. A performance of something due upon an obligation. Okay, sige. Magbabayad ako ng 50,000. Parang parehas lang. Prestation. A contract of sale and a contract of loan are examples of
Prestations, or it's either ano ba yung prestations to give or prestation to do.
no?
Hmm?
Prestations to give, prestations to do. So ayun.
Okay, so prestation is the object of the contract. It is the conduct required to be observed by the debtor or the obligor. It may be an obligation to give, to do, or not to do. The vinculum juris is also known as the juridical or legal title. Ay, wait lang. So hanggang doon lang yun. It is the contract required to be observed by the debtor or the obligor. It may be an obligation to give, to do, or not to do. So parang in this case, debtor na nga si Samantha. Tama ba?
So ayun na nga.
Tama ba? So anong ino-offer ni offer of performance by the debtor? Offer must be comply with prestation as it should be performed. The creditor refuses to accept the performance without just cause. Here, Sergio validly made an offer. So, parang debtor dito si Sergio. Sergio made validly an offer to comply with the prestation of payment, albeit for 950,000 only. Sergio's offer is justified based on the concept of partial legal compensation up to the amount of 50,000. So, in-apply dito yung legal compensation. That kind of idea that we have been discussing. Ano bang tawag doon sa Bicol? Suli? Hindi. Different pa yun, Or quits kayo in certain parts. Parang ganyan. Pero pag sinabi mo kasi pag quits na kayo, dapat totally, completely, di ba? Ano yun sa term natin? Ha?
Same level, same amount, same
Pag
something.
quits, wala na. Ex-deal eh. Quits na tayo, utang ka sa akin, may bayaran kita ganito. Quits na tayo, wala na. Completely at all, yun na yun. Legal compensation, pero
parang partial ito eh.
Ito partial lang. To the point of 50,000 lang. Since areas sa matter are in their own right, principal debtors and creditor of each other. Samantha's refusal was without just cause as she cannot be permitted to benefit or use as a defense her own failure. Bakit ba siya nagre-refuse? Wala nga just cause.
Kasi kahit bayaran niya, wala naman ng benefit sa kanya yun eh. Binenta niya na yung binenta niya na yung business.
Okay. Sige. Okay. Thank you so much, friends.
Last.
Gusto mo i-continue na lang for a few more questions as well, or gusto mo mag-break muna tapos let's resume another recording para siya na another topic, contract. Or dire-diretso na.
Recording na lang. Para separate yung niya. Para separate upload or kung ano man.
Okay, so we'll end this and then let's resume
Mm.
Maya-maya.
Ah.
Okay, thank you so much.